and good afternoon, good evening, everyone, and welcome. I'm Janice Kaminer-Resnick, and on behalf of our leadership team, former Congressman Mel Levine, former Los Angeles County Supervisor Zev Yaroslavsky, and myself, thank you so much for joining us for another edition of America at a Crossroads. We are delighted to welcome back to America at a Crossroads one of the country's foremost experts on the history, law, and even the politics of reproductive rights, Mary Ruth Ziegler. Mary has spent years illuminating not only the legal battles over abortion and contraception, but the larger political and democratic forces that have shaped them. We are enormously grateful to have her with us tonight to help us understand where reproductive rights stand today and where they may be headed. Our timely topic this evening, who decides reproductive rights, democracy, and the future of America? We are also delighted to welcome back tonight's wonderful moderator, Madeleine Brand, who is very well known to this audience. Madeleine has spent decades as an award-winning public radio host and documentary producer, bringing intelligence, curiosity, and an unfailing instinct for asking exactly the question the rest of us want answered. Madeleine, thank you so much once again for sharing those gifts with all of us. Before we begin tonight's program, let me briefly mention next week's program. On Wednesday, August 19th at 5 p.m., the Dean of UC Berkeley School of Law, Erwin Chemerinsky, will be in conversation with Pat Morrison on the topic, the Supreme Court's landmark October 25 to 26 term, What It Means for America. Dean Chemerinsky is the most frequently cited American legal scholar, and he has been named the most influential person in legal education in the United States. You don't want to miss his analysis of last year's term and his thoughts about what is coming in the October 2026 to 27 term. So we hope that you'll join us and have your friends do so as well. You'll receive an email immediately following tonight's program with information about next week's conversation and the next 4 of our upcoming programs. And if you know others who would value this kind of thoughtful, substantive, fact-based discussions we strive to bring you each week, we hope you'll invite them to join our America at a Crossroads community. Anybody who has a name and an email, if anybody who'd like to join our list, just send it to me. Respond to any of the emails I send, and we'll put them on our list. Our audience has always grown through your enthusiasm and your willingness to bring others into the conversation. That is the only way we grow our list, and for that, we are deeply grateful. And now, Madeleine, the program is yours. Thank you very much.
Thank you, Janice. Always great to be back with you. And Mary, nice to talk to you again. We've talked several times, and I always enjoy and learn a lot from our conversations. So thank you for being here. As Janice said, just to reiterate, in case you missed the introduction, Mary is one of the world's leading authorities on the legal history of the American abortion debate. And she teaches law. She's a Guggenheim Fellow, professor of law at UC Davis, and has written 6 books, which is incredible. You have written 6 books already. The latest was published last year. It's called Personhood, The New War Over Reproduction. And from your website, the description is personhood shows that the demise of Roe was never the ultimate goal of the anti-abortion movement, which was always fought for the recognition of constitutional fetal rights. In a sweeping history of the struggle for fetal rights from the 1960s to the present, she recasts the story of conservative constitutionalism in America. So hopefully we'll get to some of that, as well as talk about the latest news, which is involving the confirmation of our latest Attorney General, Todd Blanche. And before he was confirmed, I just want to get right into it. Let me give you a chance to say hi.
Nice to see you, Madeleine.
Before we get into the sort of larger goals from the conservative movement, let's talk about Blanche and what he said right before he was confirmed. And he promised a Christian group that he would make Dobbs, the decision which overturned Roe, permanent in every state. What do you think he meant by that?
Well, it's hard to know, but I think there are other context clues that what he meant was essentially that the federal government would be imposing some kind of limit, because Dobbs already is the law in every state. I mean, he could have meant simply that the Supreme Court won't overturn Dobbs, but I think what he meant instead was that the effects of Dobbs really aren't being felt really in any state. I mean, particularly in states that have liberal abortion laws, but access to abortion hasn't changed as profoundly as we expected, even in states where abortion is a crime. So I think what he was saying, if you listen to much of the rest of the call, was that the federal government and the Justice Department, with Todd Blanche now as its formal head rather, as opposed to just acting attorney general, would take steps to shut down telehealth access to abortion and potentially shut down access to abortion more broadly. And there are a few different sort of tools that are available to the Justice Department to do that that really haven't been implemented or explored yet in the Trump administration. So the million-dollar question, I think, primarily after the election as opposed to before, is whether we're going to see a dramatic change in the Justice Department to use those tools and eliminate access to maybe to all abortion, maybe to telehealth abortion, maybe to more than abortion, using some of these laws that I think Blanche sees as opportunities.
What do you mean by more than abortion?
Well, so one of the laws, one of the strategies that I think Blanche referred to in exchanges with Josh Hawley and Ted Cruz is a law called the Comstock Act, which is a 19th century obscenity law. And there are portions of the remnants of that law that refer to abortion, even though the law hasn't really been enforced in any abortion-related case in more than a century. So there's language referring to abortion that abortion opponents argue makes it a crime not just to mail abortion-related items or to receive abortion-related items. So note there that would be a potential ground to punish women for abortion, not just providers or drug manufacturers. But there's also language in it about drugs adapted for abortion, which could be potentially emergency contraceptives. There's language in it about other items for indecent or immoral use, which, you know, your guess as to what that means is as good as mine. So if that is a law the Justice Department is interested in reviving in a robust way, it could have implications beyond just abortion and certainly beyond just telemedicine abortion.
Let's pause for a second and really get into the Comstock Act, because it actually wasn't really mentioned until fairly recently, and
Yes.
in a recent Supreme Court decision, which allowed for the telehealth provisions of the mailing mifepristone and misoprostol, allowed it to continue, overruled the Fifth Circuit, which had put a nationwide ban on the mailing of these abortion drugs. And in a recent decision, 7-2, actually, the Supreme Court said, no, that has to continue for now. In the two dissents, which were by Thomas and Alito, they mentioned the Comstock Act.
Mm-hmm.
Why would they mention the Comstock Act in their dissent in this case?
Yeah, so a lot of leading anti-abortion groups have been using the Comstock Act as a potential pathway to ending telehealth access to abortion. And it's probably worth pausing to understand why they care so much about telehealth access to abortion. Obviously, telehealth access to abortion can matter in states like California, where I'm based, where abortion is legal, because there are plenty of people who don't live in a county with an abortion clinic, even in California, which has, I think, the most significant density of abortion clinics of any state in the country. But it's, of course, even more significant in some ways in states where abortion is a crime, because there have been a network of state laws and doctors that is known as the SHIELD network that's cropped up to continue mailing abortion medication and making available telehealth abortion, even in states where abortion is a crime. And the upshot of that has been that abortion numbers, to the best of our knowledge, don't really appear to have gone down very much, even though Dobbs is the law. So there's this desire to crack down on telemedicine abortion. And one of the tools that we're seeing, not only proposed by members of Congress, but also in litigation, is to use the Comstock Act to essentially say, if the Comstock Act makes it a federal crime to mail or receive abortion-related items, then there is no state law protection. Like California or New York or Maryland cannot pass a law insulating anyone from criminal consequences at the federal level. So that question is now eventually almost certainly going to be back at the U.S. Supreme Court. The next step in that Louisiana case you mentioned, Madeleine, is a hearing that will happen at the Fifth Circuit. The case is now back at the Fifth Circuit in September. And inevitably, sometime probably in 2027, the case will be back before the justices. And we don't know really if what they're going to say about the Comstock Act, because even though we know that the court did not agree with the Fifth Circuit's ruling in the sense that it preserved telehealth access to mifepristone for the moment. We don't know why that was, right? This is a prototypical ruling on what law professors either call the emergency docket or the shadow docket, where we don't know who voted how, we don't know why they voted that way, we don't know if there was some procedural or political reason animating that decision. So we're kind of in the dark about how many people are curious about the Comstock Act on the court, but we'll probably find out, sooner rather than later.
And just to reiterate, this is a law from 1873.
Right.
Yeah. It is very, very old and has, even though it's been on the books, until Roe was overturned, no one thought much about it regarding.
No, totally. Yeah. I mean, people will be familiar with the term zombie law, right? This was not a law anyone, and I mean, and I'm a historian, so I'm here, I feel very confident saying this. There were not people in the pro-life or anti-abortion movement talking about this law before the people on the pro-choice or reproductive rights side talking about this law. It was just a dead letter, right? And if anything, I think there was a desire on the part of conservatives to distance themselves from the law, right? Because, as you know, the argument for a long time had been that the point of the anti-abortion or pro-life movement was to protect the civil rights of the unborn, right? It was not to police sex. But the Comstock Act was unambiguously about policing sex. And Anthony Comstock was very clear about that, because at the time the law was passed, there was no way to tell if someone was pregnant until you could detect movement or kicking, right? So as a result, Anthony Comstock said, well, I don't care if you're taking birth control, you're having an abortion, or you're just not sure if you're pregnant and you're worried about it and you're taking a drug, because all of those things lead to sex I don't want people to be having. So for years, conservatives wanted nothing to do with this law, right? Because that was sort of everything they were saying they were not doing, right? They were saying this is not about controlling what people are doing in their intimate lives. So it's interesting and kind of, I think, potentially disturbing that there's this much of a kind of open embrace of the Comstock Act today, because it is a sexual purity law, right? Like, it's unambiguously a sexual purity law in a way that some other abortion bans are not as openly.
So it says that it is a crime to send, receive, or use the mail to transport any instrument, substance, drug, medicine, or thing designed, adapted, or intended for producing an abortion. What would a thing be?
Well, I think, and the other thing that's important too, there's actually two parts of the Comstock Act. It also includes information, right? So there's also really interesting First Amendment implications. But I think that a thing would be potentially like if you need a scalpel, or you need a surgical glove, or you need, the kind of implements that you would need. Not because I think the default is to assume we're thinking really about abortion medication. But the Comstock Act, if you interpret it the way abortion opponents do, which, by the way, is not the only way you can interpret it, or even, I think, in my view, the best way to interpret it. But if you take their interpretation and kind of divorce the law from historical context, it would apply to surgical abortion too, right? Because then you'd be dealing with any of the kind of implements you would need. And some people have asked, well, does it apply to FedEx or UPS? It applies to any kind of common carrier under the abortion opponent's interpretation. So the only way that would maybe not apply is if you lived in a state that manufactured its own stuff, right? So you're not actually putting it into interstate commerce in the same way. But that's just at the moment not how our medical system is set up, right? So there's pretty much most abortions in the United States today involve drugs and medical equipment and other items that are put into interstate commerce. So that's the reason I think you see so much investment in this argument, and why, in particular, it was revealing that Todd Blanche was discussing that law in particular, because it would not just be about mifepristone, it would be potentially about abortion access, full stop, altogether.
So when he's discussing that, does that mean he would use the Department of Justice's resources to prosecute anyone who mailed mifepristone?
Potentially, right? I mean, we don't know. But that would be the mechanism for enforcement of the Comstock Act. So the last official word we heard about the Comstock Act, amazingly, was actually from the Biden administration, which issued a memo saying, we're aware of the Comstock Act, but courts have not interpreted the Comstock Act in this literal way. that abortion opponents are proposing quite literally ever, right? Both because of what the word abortion meant historically, and because there was a long-standing assumption by judges and doctors and even Anthony Comstock that the law would not apply to at least some abortions. So we haven't heard anything from the Trump administration since then. So the question is really, the Justice Department could start enforcing the law, right? They could withdraw that Biden era memo and institute their own and begin prosecutions. I think the $1 million question there is just whether Todd Blanche was saying what he needed to say to get confirmed, and there will in fact be a major reversal from the Trump administration, or whether the Trump administration will continue to kind of slow walk anti-abortion priorities, which it has been doing to date. It's been less visible with the Comstock Act than it has been with the FDA. But there hasn't really been much movement from the Trump administration on telemedicine access to abortion, even though there's been really tremendous amounts of pressure from the anti-abortion movement. And I think what's unclear to me is whether that will change after the midterm when the president no longer feels that he'll be jeopardizing his control over Congress by catering to what base voters want. Or whether instead this just simply isn't an issue he cares about and he's going to continue ignoring those demands even after November.
Has anyone used the Comstock Act actively and its success?
I mean, for some things, right? So the Comstock Act, because the Comstock Act was so sprawling, it also contains provisions on obscenity, which are often used in child pornography cases. So there has been a debate, obviously mostly academic at the moment, given that Republicans control both houses of Congress, about what Democrats should do about the Comstock Act were they to regain control of Congress. And one school of thought says the Comstock Act should be repealed outright because it's archaic and it has a long history of being applied in disturbing ways. Other Democrats have said instead the Comstock Act should have its disturbing language excised, but the rest of it should be left behind because it is sometimes used in selective obscenity prosecutions that some Democrats stand behind. So again, neither of those things is happening imminently, but I do think that that's a conversation that probably the Democratic Party will have depending on how the election is going, because unless or until this argument is definitively rejected by the US Supreme Court, it's going to continue to be available, if not, to the DOJ tomorrow, then, in 6 months or a year or the next Republican presidential administration.
Right. And when you say repealed, of course, the president would have to sign that.
Right. Yeah. When that would be entertaining, right? It would be entertaining to see what Donald Trump would do faced with a Comstock Repeal Act. Because of course, as we all know, right, Trump's go-to line has been that everyone wanted Roe v. Wade to be overturned, which isn't true, but that now that Roe v. Wade is gone, he's going to let each state make up its own mind. Was never really going to be possible, of course, because the states are at war with one another. But it's certainly incompatible with the idea that it turns out that there's been a stealth abortion ban on the books since 1873 that none of us knew about. That is not letting the states do their own thing. So it would be really interesting to see how the president would respond to a bill like that if one landed on his desk.
So the number I saw is that 2/3 of all abortions are now medication abortions.
Right.
And that there are more abortions now than there were pre-Dobbs.
Correct. Yep.
And in general, the American public supports some form of access to abortion. So it's politically not perhaps a good idea for Trump to take this on at this moment when he's so unpopular.
Exactly. And I think now also Trump is not a lame duck now in the way he might be after November. So he's acutely aware of the fact that if he loses control of the Senate, for example, there are no more appointments that are going to sail through or judicial nominations. If he loses control of the House, there could be impeachment proceedings. Like he still has lots of skin in the game. So the question for me becomes whether he views the issue differently after the midterm, because of course there's still conversations afoot about whether Trump can somehow run again, notwithstanding the 22nd Amendment and the fact that he's disavowed plans to have him run as vice president. But if you set aside the possibility that he would run again, he would have a different set of incentives potentially after the midterm than he would before. But absolutely, I think that's the reason he hasn't done anything yet. It's a combination of the fact that doing so would be deeply unpopular and also seemingly making a move on reproductive rights is not a priority for him, because of course the president is doing other things like the Iran war that are also unpopular, but that he seems more invested in than he does in this issue. With the exception of maybe birth control, right? Which is another weird facet of where we are today.
Okay, just one more thing on that. Well, maybe not just one more.
Yeah,
But,
it's okay.
so I guess I'm wondering, what is your assessment of Todd Blanche? Like, is he a true believer? Will he do whatever Trump wants him to do?
But very much the latter. So Todd Blanche has a history of being pro-choice, which frankly, so does the president. Todd Blanche, I think, rose to the position he has assumed because of his loyalty to the president and his willingness to do what the president wants, not because he has a pre-existing set of ideological commitments. It's hard to know then how to read some of the conversations he's been having with members of Congress and religious figures, because it doesn't seem necessarily that he personally is deeply committed to the things he's saying. It also may be more revealing, right? Because I don't think there are many things that Todd Blanche says or does without the president having somehow vetted or approved them. Because again, that's what he's there to do and why he has won over the president. So it may be more revealing, right, that he's saying this sort of thing, given that he almost certainly cleared it with the president first. But he's not a true believer. And interestingly, there are people in the Trump administration who are true believers in terms of social conservatism, but relatively few. And I think especially as compared to, say, the first Trump administration, where Mike Pence was, I think, kind of passionately opposed to abortion and passionately socially conservative in a way that I don't think J.D. Vance or others in kind of like Trump's immediate circle have proven to be.
Okay, so what do you think is going to happen in September with the Fifth Circuit? And I mean, there is a prohibition via another Supreme Court decision on lower courts issuing nationwide injunctions. This is what the Fifth Circuit did, and the court said, no, you can't do that. But if they do decide to do that on a different basis, what would happen?
Well, I don't know if the Fifth Circuit, I don't think will try to immediately change access to mifepristone because they got slapped down by the Supreme Court before. But I do think when they're reaching the merits, right? Because at this point, when the case is coming back to the court, the question is not going to be what are the terms of access going to be as the litigation continues. The question is going to be who should win on the merits when the case ultimately returns to the court. And we already have a pretty good idea that the Fifth Circuit is going to side with Louisiana because the Fifth Circuit already said it was going to do that the last time when it ruled on what it wanted the terms of access to be in the interim. So I think it's very likely that, one, I don't think mifepristone access will necessarily change much after the Fifth Circuit rules, but that two, the Fifth Circuit will tee something up for the Supreme Court saying, we think mifepristone access needs to fundamentally change. And the court will then have to answer the question on the merits, which it didn't have to do before, right? It could have been ruling on the national injunction point. It could have been ruling on standing. It could have been, because we don't know what they were thinking, it could have been that they just didn't want to do this before the midterm, right? We have no idea what they were doing because it's an emergency docket order. And we don't know how the votes broke down, right? So it could have been very close or not at all close. And the fact that only Thomas and Alito wrote dissents doesn't tell us anything about the vote either. It just tells us that they were the only people motivated enough to complain about it. But I would strongly suspect, given the Fifth Circuit's earlier ruling, that they will stick to something like that and potentially even expand it, right? The Fifth Circuit's earlier ruling was really focused on procedural issues. Since the court overturned Roe, it has been very hard for abortion opponents in federal cases about abortion access to find someone who has standing, right? And the Fifth Circuit pretty much talked about that to the exclusion of anything else. But so I would expect the Fifth Circuit to say again that Louisiana should win, but maybe even elaborate more on the merits about why Louisiana should win, teeing up something probably significant in the Supreme Court.
Meanwhile, last month, a federal judge ordered the FDA to review its restrictions on mifepristone because he said it's safe, and putting restrictions on it, on dispensing it, are arbitrary and capricious. So the FDA is undergoing a big review, and even though these drugs have been deemed safe for a quarter of a century or so.
Right.
And there are hundreds of pages
More,
to
actually.
go through and all of that. I'm wondering if they could come to the opposite conclusion than the judge intended in his order, and
Yeah, I mean,
find that they are dangerous and ban them.
absolutely, yeah. So the FDA began, well, when the FDA began the review, as reporting from Wall Street Journal and other sources have established, was actually much later than it was claimed to have begun. But the FDA's review began prior to the recent judicial ruling, in part because abortion opponents had produced a study by an organization called the Ethics and Public Policy Center, saying that the adverse incidents related to mifepristone were in fact much higher than the FDA had previously understood. And that spurred the Trump administration to agree to a study of mifepristone safety, which it turned out the Trump administration didn't actually begin until much later, but now has apparently begun in earnest. So the FDA is under these kind of clashing commands. So the district court in the Fifth Circuit case in Louisiana has said essentially, I, the district judge, think that mifepristone probably isn't safe, but I'm going to give the FDA a certain amount of time until actually October of this year to finish the study and give me an update. Then you have another judge saying, in fact, the FDA needs to study mifepristone because it's safer than the FDA has established, and the restrictions on it are unnecessary. So the FDA is now under these kind of dueling commands, with October as at least not necessarily when we're going to get study results, because the Trump administration has indicated again that it has no interest in releasing these results until after the midterm, which at this point shouldn't surprise anybody, but that there will be some kind of update to satisfy the Louisiana judge in October. I think given the politics of it, it would be much more surprising for the Trump administration's FDA to conclude that mifepristone is actually safer than the Biden FDA thought it was. But, you know, I think it's still significant insofar as you have an airing of more of the scientific research about mifepristone that's coming into public debate as a result of this litigation, as opposed to, you know, what have been a lot of kind of talking points that have come from some of the studies that advocacy groups have been putting forward.
And they're not looking at the safety of the other drug, misoprostol.
Well, yeah, they will eventually, I'm sure. But the one of the reasons mifepristone has been the target is because the FDA approved mifepristone only for abortion, right? So going after misoprostol is a lot more complicated, not only because misoprostol is used in miscarriage management, which mifepristone is as well. Misoprostol is also one of the most common drugs that's used in ulcer management. So there are people who have, you know, nothing to do with pregnancy whatsoever who are commonly using misoprostol. So strategically, I think abortion opponents thought it would be easier to isolate mifepristone because it would get less blowback from other patients, other drug companies. And that's been true up to a point, but there actually has been backlash from drug companies, which don't like the idea that, you know, advocacy groups and activists can roll up decades later and second guess the FDA's drug approval process. Because if that was true, you could imagine something happening with, you know, MMR vaccines and HIV prophylaxis and drugs used for infertility. Like, who knows where that would go, right? So I think there's an interesting question looming in this case about if the Supreme Court or the Trump administration does what anti-abortion groups are asking, will that have ramifications for the way we do drug approvals for everyone, right? Not just for people who are abortion seekers or people who are having pregnancy complications.
Okay, is there anything, any case that you're looking at that we haven't discussed that you think we should pay attention to? Perhaps that will be in the next term, or that's working its way up through the circuits?
Yeah, I mean, those are the big federal cases in the near term. There are a lot of other cases involving the FDA that are kind of being put on hold for the Fifth Circuit case. So a lot of those are also waiting, but I would expect those to get consolidated. There are other attacks on Shield laws that are not likely to go to SCOTUS as quickly, but they are percolating up the pipeline. Those are often suits brought by individuals who are suing for wrongful death in federal court. Sometimes they're suing doctors who mailed pills into their states. Sometimes they're suing those people as well as a drug company or even a former partner who they allege gave them the drugs or purchased the drugs. Those cases also involve the Comstock Act, and they involve another question, which I think is in the background of cases also involving attorneys general suing doctors in blue states, which is essentially if the Comstock Act isn't involved And if the FDA doesn't change access rules on mifepristone, what happens when the states are just fighting with one another? Like, how do we resolve which state's law wins and which state's law loses? And there are federal cases raising that issue as well as the Comstock issue. And they're earlier on in the process. So I would expect those to maybe take another year to get to SCOTUS, or maybe a year and a half. So we're not looking at that being something we're going to see as quickly. But sometimes those cases move more quickly on an emergency basis too, right? Like as we saw with the Fifth Circuit case, these things can sometimes accelerate quickly. But those are ones I'm also watching because we're looking, there is an inevitable clash, a kind of civil war of the states that's going to happen as to which of these states' laws prevail, unless there is a kind of federal limit imposed. And there are already at least 3 or 4 of those cases in the pipeline. It's also worth paying attention. I mean, some people may remember the Alabama Supreme Court issuing a ruling declaring IVF embryos to be people in 2024. That's a good reminder that we should also pay attention to state cases, because state cases can sometimes have national ramifications. 2 that I'm particularly paying attention to in Missouri and Florida involve lawsuits against Planned Parenthood, arguing that by saying mifepristone is safe, Planned Parenthood is committing multiple massive acts of consumer fraud. So the Attorney General of Missouri and the Attorney General of Florida are seeking hundreds of millions of dollars in damages against Planned Parenthood. And they're deliberately doing that in state court where they expect a more sympathetic audience. So that's a good example of how we have to pay attention to state cases, because if Planned Parenthood was having to pay, $800 million in damages to the state of Florida and the state of Missouri, even if that's not a national ruling that affects us all, it would dramatically, of course, affect Planned Parenthood.
Yeah. Well, so getting back to your Civil War comment, which probably raised a few eyebrows, you're basically referring to simplify it, red states that have enacted very strict restrictions on abortion or bans on abortion versus blue states who have enacted shield laws, like in California, to protect doctors who send the medication to these states, correct?
Correct.
Being
Yeah.
prosecuted for aiding and abetting abortion. And so this would be argued under what provision of the Constitution?
So generally how this would work, and we've already seen this start in New York, right, is you would have a Texas attorney either file a lawsuit or pursue a prosecution. And of course, the doctor from New York or California will then not show up, right? And there will be a default judgment or an attempt at extradition. And eventually, the extradition piece of it, I don't think is going to work. I don't think it will be easy to extradite doctors because of the way the constitutional law there works. But there's one piece of it, the criminal piece, the constitutional provision is the extradition clause, right? Like, when does a state constitutionally have an obligation to send someone who's alleged to have committed a crime to face prosecution elsewhere? If it's a civil suit, right, we've also seen attorneys general and individuals suing for lots of money. Then the question, it comes down to what's called the full faith and credit clause, which involves when one state has to honor the judgments of courts from other states. And it turns out that that's actually quite messy too, and that it's harder if you're a state that's suing, right? If the person that, or the entity that's the plaintiff is the state government, it's actually harder to get another state's courts to enforce your judgment than if it's an individual citizen suing. So those are the 2 big constitutional questions that are in the background, in addition to some substantive questions involving the First Amendment, because people who are getting sued now are not just doctors, but also entities like Mayday Health that provide information about abortion online, right? So those cases are going to involve questions about whether you can prosecute or sue someone just for information, or whether that violates the First Amendment and the free speech clause.
And Josh Hawley from Missouri is trying to do that with a group called Plan C.
Exactly. Yeah.
Which is they don't send abortion drugs, they just are a referral service or an information clearinghouse for where.
Yeah, I mean, they're not, I wouldn't even call them a referral service. It's more like an online database where you can find information about where to buy things. Like a referral service suggests a certain amount of like active participation, like they would get a referral fee or something. And to my knowledge, that's not true of Plan C or Mayday. They sort of pitch themselves as educational organizations that don't really tell you what the right decision to make is. And a referral service usually is not that, right? So yeah, I think Josh Hawley referred Plan C to the Justice Department, as members of Congress can, for investigation. And South Dakota recently passed a law saying that abortion-related advertising was a crime in the state, and that's a case that's now gone into court, into federal court as well. So another interesting angle is whether the country's fixation on reproductive issues is going to undermine free speech, right? Because, I mean, if you can't talk about something that's not only legal, but is also constitutionally protected in a majority of states, that would be a pretty big deal from a free speech basis, right? If one state criminalizing something means that talking about that thing becomes criminal everywhere, you can imagine how that would be a pretty significant change as far as the First Amendment is concerned.
What now, I'm just vaguely remembering this because my memory is poor, but didn't the Supreme Court rule against California in a similar case, but from the opposite perspective? California was trying to limit crisis pregnancy centers from dispensing erroneous information.
Yeah, it was a slightly different argument, right? So California wasn't saying that crisis pregnancy centers were committing a crime because they didn't say they were doing that. They just said California mandated that crisis pregnancy centers communicate certain messages for the purpose of like patient information or safety. And the Supreme Court said that they don't have to do that. But what the red states are saying now that's different is they're saying, well, abortion is a crime. And speech incident to a crime isn't protected. So like if I want to go hire a hitman and I have a conversation with him about hiring him, my speech isn't protected, right? Like if I'm, someone from the mafia and like I order a hit, that's not protected. So the red states are saying essentially that if you are providing information about abortion, you're facilitating a crime. You're not just speaking a message. And of course, the interesting question then is, well, who gets to decide if it's a crime, right? Is it the state where, Mayday or Plan C is headquartered that doesn't think it's a crime? Is it the state that's criminalized abortion? Is it something else? And also, what does even mean for speech to be incidental to a crime, right? Like, I mean, there's different levels of proximity. Like, maybe providing information about abortion makes people more likely to have an abortion than if they don't know anything. Maybe political advocacy for abortion does that too, but that seems pretty far removed from my hitman example, right, where the speech is the crime.
Well, also, I mean, you could imagine any internet search would then be criminalized if you searched mifepristone.
Totally, yeah, and that's one of the things that I think is looming in the background, that we're starting to see members of Congress and states attorneys general and state legislators looking at ways to criminalize information, and that makes sense, I think, not constitutionally, but it makes sense logistically, because red states have been so unable to limit access to telehealth abortion that they're now looking at ways to eliminate access to information about it. So people don't know how to obtain it, even if they can't actually effectively prosecute people who are obtaining it.
Okay, so in the last elections, we saw a flurry of states enact constitutional protections for abortion, for reproductive rights. Are we seeing anything along those lines in this election?
We are. So we're seeing there are several ballot measures that are moving forward. Some of the ones I'm watching the most closely, or I think are the most interesting, on the sort of side of potentially expanding reproductive rights, you have Idaho, which would be a really important potential change. Idaho has one of the narrowest set of exceptions to its abortion ban in the country, and is for that reason the subject of another really interesting lawsuit, which I also think will take a little longer to get to SCOTUS, but which will be there, which argues that even though Roe is gone, there is a federal right to abortion if you're going to die or have your health permanently and severely compromised if you lose access to abortion. So Idaho may see some kind of reproductive right restored. On the other extreme end of the spectrum, you have Missouri, which actually voted to establish reproductive rights in the last election cycle. Republicans had put a ballot measure forward there that they initially positioned as allowing access to abortion in cases of things like threats to life and rape and incest, but which in fact bans all other abortions except in those circumstances. And Republicans are billing this primarily as a way to ban access for gender affirming medicine for transgender youth, even though that's already illegal in Missouri. So this is a kind of new attempt to get around popular support for reproductive rights by focusing voters on transgender issues, which don't poll as well. So we have kind of both ends of the spectrum where you're going to see potentially red states voting to expand abortion rights. There's also blue states voting to kind of entrench, or at least purple states to entrench abortion rights further in the case of Nevada. And then you have a red state where Republicans are looking for a way around the popular support that abortion rights enjoy with this new kind of experiment.
Okay, you mentioned gender, so let me zig into that direction and the trans rights direction for a second. The Supreme Court had a big ruling this past term, West Virginia v. BPJ, which allowed the state to separate athletes on the basis of quote unquote biological sex. So how do you read that ruling? Because most of the justices agreed that under Title IX, that is allowed, that you can have sports for girls and sports for boys.
Yeah, I mean, I think on the one hand, so the court kind of positioned BPJ as a relatively minor ruling, right? So the idea was that sports are just different, and there are obviously physical differences between people who are assigned male and female at birth when it comes to sports. The thing that was a little bit disturbing about the case to me, outside of that, was that the court applied a kind of watered down version of the kind of scrutiny it usually applies to sex classifications. It cited a lot of cases that are usually very deferential to the legislature. And it picked up on a lot of the language that social conservatives have used, not just to take anti-trans positions, but also to denounce sex discrimination law more broadly, right? So there were some kind of tells in the court's opinion that they've been hearing and are at least somewhat receptive to constitutionalizing these positions. So I think the way to understand that case is not just that it's certainly obviously about the LGBTQ community, but it's also about sex discrimination law more broadly. And one of the reasons I think that's certainly true from an advocacy perspective, because within a few weeks of the court's decision, the Heritage Foundation rolled out a big white paper saying essentially that Title IX, which, as everybody knows, funds women's athletics and has sort of made U.S. women's athletics the envy of the world, that it was a mistake. It was like feminist social engineering, that women should be encouraged to do things that would kind of direct them toward motherhood and childbearing, like yoga and cheerleading, that make them more graceful, and that competitive sports for women make them infertile and manly. Like the idea that this was about protecting girls and women went away pretty quickly when the court ruled. So I think it's right to read that case not only as something where we're going to see more sort of investment in cases involving LGBTQ folks, but that being a kind of Trojan horse for going after sex discrimination protections that apply across the board in every context.
So you think that the ultimate goal is to get rid of Title IX protections?
Yeah, that's one of the goals, right? I mean, I think, and to water down sex discrimination protections, because now, interestingly, right, a lot of the cases that trans people and gay and lesbian people had relied on were cases involving sex discrimination for straight cisgender people that the court had instituted over the course of from the 70s really to the 90s, because the court had ruled that even though, of course, there are real differences between men and women, and those may include differences between trans athletes and cisgender athletes, right? But that you can't just say, okay, people are physically different, so there can't be stereotypes here, right? Lots of people know that pregnancy is one of the main reasons that people have been fired, people have been demoted, people have been underpaid, and there's no question that pregnancy is a real biological difference. So the move that the court made that worries me is not to say that trans and cisgender athletes may be different. They are different often, and they may be different all the time. But it was to say we don't even need to look closely at this, because when people are physically different, there's no stereotyping. American history tells you that when there are physical differences, that's often when you have some of the most horrendous stereotyping, whether you're talking about race or sex or anything else. So I think the ultimate goal really is to say that the sex discrimination law as we know it is a problem in general, right? Not just in the context of cases involving sexual orientation or gender identity. And Title IX is a piece of that. And to be fair, I think conservatives are divided about whether to get rid of Title IX, as they're divided about some other gender questions. There's been an uptick in things I didn't have on my bingo card and people thinking women shouldn't vote. I don't think that's a uniform position either, but it's certainly not as marginal a position as I would expect it to be or would have expected it to be. So I do think that that's something to keep an eye on, that we're seeing, I think, a move to change sex equality law as dramatically as abortion law has been changed already.
Wow. Okay, on that note, let's get to some of the questions. All right, from back to front. Nina says, can you tell us how the abortion bans in states like Texas are affecting access to abortion, even with the availability of medication abortions? I've heard that in Texas, with its snitch law, some women don't feel safe doing medication abortions in the state and are traveling to other states just to take the pills.
Yeah, there definitely are impacts on, because people are unsurprisingly unaware of what the law is because it's changing all the time. Like if you need to have an event where you bring me in to talk about what's going on, ordinary people are not necessarily going to know what's going on, right? And they're going to not want to risk, jeopardizing their own situations legally or those of their loved ones. The other piece I think that's really significant to talk about is that mifepristone access doesn't help you if you need an abortion later in pregnancy. So a lot of the people who are feeling the effects of Dobbs most acutely are people who have wanted pregnancies, who are suffering complications later in pregnancy and are unable to continue that pregnancy without either, miscarriage, stillbirth, or some real threat to their health. And in a lot of those cases, doctors are unwilling to intervene because they think that doing so would be considered an illegal abortion. So one of the kind of ironies, I think, of the post-Dobbs world is that we're seeing more abortions and we're seeing pretty common access to early abortion. And then we're seeing people who aren't really necessarily even abortion seekers in the way we would conventionally think being denied access to emergency interventions because there are fears from doctors that they would be considered to be violating the law. So I think that's a huge piece of what we're seeing in states like Texas, and red states have tried to clarify when doctors can intervene under exceptions, but those clarifications haven't been very illuminating, in my opinion. And there's research undergoing by folks at the University of California, San Francisco, that documents that doctors are still turning away a lot of patients, even under these laws that have nominal clarifications, because they're not clear enough, especially given the kind of legal jeopardy doctors face if they get wrong.
Andrew asks, mifepristone is also used to treat other conditions such as Cushing's syndrome under perhaps a different brand name. They can't outlaw medication that is treating other non-abortion related conditions, right? I guess they could restrict it to just.
Yeah, they can. And I mean, and I think because it's only FDA approved for abortion, that's really the Achilles heel, right? Because they can say, yes, it's used off-label for lots of things, but if it's FDA approved only for this one thing, we think it's an abortion pill, and we can ban it as such. There are, of course, other protocols for medication abortion that don't use mifepristone at all, but there are reasons why they're not the current gold standard. So there has been talk already, given if it's the Louisiana case that will go back to SCOTUS, about what would happen if mifepristone telehealth access ends, or if mifepristone's removed from the market altogether. And there are alternative protocols that are available, but they tend to have higher rates of side effects, which mean more people who tend to seek urgent care, which of course would then tee up an argument about misoprostol. So while there wouldn't be an end to telehealth abortion, regardless of what happens to mifepristone, there would be, just another round of fighting about the next drug that's being used in a protocol.
Right. Joy asks, I guess tongue in cheek, is Viagra within reach of the Comstock Act as well?
Yeah, I mean, maybe, right? I mean, I don't think anybody would do that, but that's your guess is as good as mine, because Anthony Comstock, when the Comstock Act was being applied in the 19th century, it was applied to all kinds of weird stuff. Like, as you can imagine, like, what are other items for indecent or immoral use? Like, certainly, like, maybe Viagra, right? So I think that there's obviously lurking in the background there. If I don't know what it means and you don't know what it means, that's a constitutional problem. So there may be a due process or kind of vagueness argument lurking there, that if no one knows what the Comstock Act actually means in certain respects, then it's not constitutional to enforce it. It's kind of like you can't constitutionally change the rules in the middle of the game. So I think, one, I don't think the Justice Department would enforce it against Viagra, and two, if they tried to use that other indecent and immoral uses piece, I think there'd be a pretty strong constitutional challenge, just because that would be right up there with the vaguest laws you would see a prosecutor trying to enforce.
Yeah. Ruth and others asking, what are the chances that if Dems get a majority in Congress, that they'll come up with laws to allow abortion or to overturn SCOTUS's overturning Roe v. Wade, given that Congress, not SCOTUS, is the last word on this?
Yeah, I don't know. I mean, I'm a little bit of a cynic because the Democrats have had multiple chances to pass federal legislation protecting abortion rights. Obviously, the most recent was killed by Joe Manchin, but then if you go further back, there was no Joe Manchin, right? So this would have been possible in the Obama era, that would have been possible in the Bill Clinton era, and Democrats always thought other things were more important priorities. Obviously, that was in an era where Roe v. Wade was on the books, so maybe that changes now. But I guess I'll believe it when I see it. It's my attitude because as a historian, every time the opportunity has arose or has arisen, Democrats have found a way to not do it. And so until I see evidence to the contrary, that's still my guess as to what would happen.
All right, this is more of a philosophical question from Shuli. Since abortion is still a religious question, and given separation of church and state, wouldn't it make more sense for there to be no government laws, state, federal, or local, right? Abortion, the decision would be private between a woman and her doctor. The private sector would have to pick up the tab for abortions. Do you agree? If not, why?
Yeah, I mean, I think it's obviously a religious issue, and it's also, I think, more obviously a religious issue now than it was historically. One of the sort of interesting features of today's debate is how often leading abortion opponents say that what they're doing is religious. So the Alliance Defending Freedom, which is the group that litigated the case that got rid of Roe, describes what it's doing as ensuring that the law reflects God's good plan or is in step with the design of nature's creator, right? I mean, this is not held out to be a secular thing. There's a growing group of people in the anti-abortion movement who are calling for the punishment of women for abortion, again, on scriptural grounds. That's now the position taken by the Texas Republican Party's platform. It's growing in support. So given that this is more obviously religious even than it had been before, you would think that would be a good idea. But of course, one of the weird features of American law, which is not quite unique, but certainly unusual, is how much abortion is a partisan issue here. That's not something you see in a lot of parts of the world. And in light of that, how much our policy does not reflect our views as a people, right? Like there is more of a mismatch between policy and polling in the United States than there is anywhere in the world. And so I think, you know, I do agree with that, but I think descriptively, we're not likely to see that anytime soon, both because there are a lot of financial and political incentives for people to not do what voters want and not let this be a matter of conscience, and also because we're heading in the direction of actually some people being more comfortable using law to reinforce religious beliefs, even if others don't share them, than we might have been in the past.
What other area of the law or of religious belief do you see as totally mismatched between what people believe and what the laws are or what the people in power want to do?
I think IVF's another good example. I mean, we're now, I mean, as everyone knows, President Trump said he was going to be the fertilization president and we were going to have like cheap access to IVF. And instead, what we've seen is Republicans killing bills that would offer military members IVF insurance coverage. And it's worth sitting with that for a minute because unsurprisingly, men and women in our armed services have higher rates of infertility because they're exposed to toxins as they serve our country. So they need infertility treatment more than the average member of the public would. So I think, and IVF is actually more popular than abortion access, which is, you know, abortion access is really popular, but IVF is really popular. And yet we live in a country where there's no national protection for IVF. And when IVF is astronomically expensive and often financially out of reach for a lot of people, including our armed services, but for other people too. So I think that's another example. And it's for similar reasons, right? I mean, IVF has become a culture war issue since the fall of Roe. But the fact that our policies look the way they do there, I think is another good example. At the moment, you know, it's not true of contraception, but we are seeing the Trump administration has rolled out plans for next year to overhaul both sex education and family planning to kind of reorient it toward encouraging conception rather than contraception. and encouraging natural family planning and moving away from more proven forms of contraception. That would be out of step with popular opinion too, but that's sort of something that's in transition more than something that's already been accomplished in the same way.
Yeah, I wonder if guns is another issue where.
Yeah, I think that's probably right too. I don't know the polling on guns as well. I think that's more like evenly divided, but I could be wrong about that.
Right. Okay, let's see. What is the status of abortion rights in Europe and elsewhere?
Mhm. So as I mentioned, we're somewhat of an outlier. There are countries in Europe that have outcomes very similar like ours, like Poland, where you had a court, a high court that had been reshaped by conservative politicians, transforming access to abortion. Most of Europe allows abortion broadly until at least, the 14th, 15th week of pregnancy. That's the status quo in Europe. Our anti-abortion movement has been exporting stuff to Europe. So Reform UK, which is the kind of leading populist party in the United Kingdom, has been working with American anti-abortion groups. So there may be more restrictions in the UK than there have been recently. The anti-abortion movement in Belgium is growing, and Ireland is growing. So we may see more kind of dovetailing of US and European policy than we have seen to date. Generally, abortion access in the global south is a lot more restricted than it is even here. That's true. There have been shifts there in recent years in parts of Africa. And there have been shifts, I think, in general in parts of Asia as well. But there's always sort of, I think, in a lot of parts of the world, notes of caution where you'll read stories about judicial victories, but those don't always translate into access on the ground. But I think if you're really, really zoomed out, the general trend has been toward more access in most parts of the world, and less access in places often where there is this kind of partisan politics around abortion. That's true in Brazil, which has been going the same direction in the United States away from access. It's true in Poland. And when you see, I think in parts of Europe, abortion beginning to become more of a kind of partisan football, that's when you begin to wonder if there's going to be a kind of similar path traveled.
Yeah. So overall, you've seen in terms of tactics, the conservatives are playing the long game with a lot of issues, but with abortion in particular. Have Democrats, after the fall of Dobbs, have they learned any lessons from that? And are they playing maybe a longer game or have sort of a grand strategy for restoring reproductive rights nationwide?
I think they're trying to develop one. I mean, I think that part of the problem Democrats have had with respect to reproductive rights, one issue I think is just an addiction to the courts. There was so much time spent on preserving Roe that I think what the movement is really good at the moment is fighting in court. And if what is needed to move from where we are now to where we need to go is more than that, I think there's lots of things that need to be developed. Democrats as politicians tend to be as focused on reproductive rights as the polls tell them they should be, which means, it's very uneven and not the kind of thing you would need to play the long game. Um, so I think it's in progress. I do think that there's been more awareness among progressives that a bigger rethinking of strategy is needed, right? And that the same things, obviously, that progressives have been doing brought us to this moment, which is not where progressives necessarily want to be, right? But I don't think there is yet a plan in place, and that isn't that concerning to me, I guess, because it took conservatives a long time to develop a plan to get rid of Roe that worked. And so I think that kind of movement progression is something that naturally is slow and involves a lot of experimentation and deliberation.
But they do have the Supreme Court now.
Yeah, they do. And that's dangerous, right? I mean, because they have the Supreme Court unless or until Sam Alito or Clarence Thomas retires or dies, right? I mean, and that was the mistake I think progressives made to some degree, right? So I think having the Supreme Court is both amazingly powerful if you're a movement and also kind of seductively dangerous because the court can't fix your problem. The court can't win you hearts and minds. The court is not a strategy by itself. It's a hugely powerful institution that has to be part of a broader strategy.
Well, that's a good note to end on. And Thank you so much for joining us again. It's always been very illuminating and interesting, and thank you for your time.
Yeah, it's been fun. I always love having these conversations. Thanks for having me.
Oh, it is my pleasure. And don't forget to join us next week when the Dean of the UC Berkeley Law School will be with us, Erwin Chemerinsky. He'll be in conversation with Pat Morrison, and I'll be back with you again soon. Thanks for being here. Have a good night.